The Florida legislature passed State Statute 768.79 to encourage the settlement of pending lawsuits. The law provides that if either party makes a formal offer to settle the case, the other side rejects the offer, and you go to trial and beat the offer by 25%, then the penalty to the party forcing the case to trial is that they may have to pay attorney's fees to the party that made the offer. Sounds simple, but I assure you proposals for settlement are complex and unique to each case. There's a lot of strategy that goes into the timing of a PFS and the amount that is offered. This video is a simple overview of the process, and you should speak with me personally about how a PFS made by you or against you may affect your case. Let's first talk about timing. A plaintiff can't immediately file a PFS. They must wait at least 90 days from the date a lawsuit is served to give the defendant time to evaluate the claim. A defendant, however, can make a PFS as quickly as 45 days after a complaint is filed. Neither party can make a PFS less than 45 days prior to the case going to trial. And each party has 30 days from when they get a PFS to accept or reject. Let me give you a couple of examples. Let's say you make a PFS to the defendant in the amount of $10,000. That PFS is rejected and your case goes to trial. If you receive a net verdict of $12,500 or more, then the defendant may be responsible for all of the attorney's fees from the date the PFS was filed for not accepting the 10 grand and making you go through the time and expense of taking a case to trial when they should have accepted your offer. Now let's consider if the defendant makes a PFS to you in the amount of $10,000. If you reject the PFS and proceed to trial, you may be responsible for their attorney's fees if you fail to recover at least $7,500 for forcing them to go to trial. Now that you understand the basics, let's talk about some of the strategies to consider when making a PFS. This is where the unique facts of each case greatly affect when to make a proposal and how much to make it for. Obviously, we want to make a PFS for as low as possible so we have a number that we have a good chance to beat. But we always run the risk of the other side accepting the lower amount. It's important to look at the prior settlement negotiations in each case to determine what to offer. Let's talk about what happens after a trial to determine whether a party is entitled to recover attorney's fees. When a jury decides a verdict, they are asked to answer several questions and determine dollar amounts for different types of damages. Once a verdict is rendered by a jury, that's not the end of it. The judge must then determine what the judgment amount will be. The judgment amount is what determines if you have won or lost the PFS. The verdict amount can be increased or decreased by costs, what was paid by PIP, or health insurance. The law also doesn't limit how many proposals can be made from either side, and it may be good strategy to file a PFS prior to mediation, and once we know what their top offer is at mediation, to adjust our PFS to increase our chances of beating the proposal. Using a PFS can be an invaluable tool when you have a case with issues that could limit the recovery. The reality is that trying a case is expensive in both time and costs. Using a PFS to leverage the return on a case enables us to dedicate the additional time and resources to a case that otherwise would not be worth taking to trial. Insurance companies have the luxury of choosing which cases they will try or settle, and making a PFS can help level the playing field. I hope you found this video informative and helpful in understanding the complexities of proposals for settlement. I look forward to discussing how we can use this tool to increase the chances of recovery in your case.